Good afternoon, everybody. And for those of you who watch the recording of this at some other time of the day, don't be disoriented by that. My name is Ken Director. I just celebrated my 36th year with the firm. I am the chair of the Community Association Practice Group, and I am joined today by two longtime colleagues. First, Jelini Goen, who works out of our Orlando office. Jelini has served as our call liaison for several years, and she has been our point person on legislation for quite some time. And my other colleague joining us is my partner, Steve Messer, who works out of our Tampa office. Steve has been in practice for longer than he'd probably care for me to mention, but he also closely follows and provides input into the legislative process annually. So folks, at this point, the legislative session for 2022 is probably best known for what didn't happen. But I'm told there is a special session currently in progress, and that the governor has said he intends to call a second special session for sometime next month to address the bills that have everyone's attention dealing with safety and the fallout from the collapse of the building down at Surfside. But for starters, let's go through some of the bills that passed, just so you'll know what is coming into the law. And Jelini, the Marketable Record Title Act, I think it's important to point out that this doesn't apply to everyone who's listening. It certainly doesn't apply to condos. But there was an amendment to it. Can you address it briefly, because it is of limited impact to the people listening?
Sure. It is the Marketable Record Title Act was amended to, and the amendment deals primarily with how MRTA, which is what we call the Marketable Record Title Act, impacts things like zoning ordinances, comprehensive plan amendments, and land development regulations. So that's not something that would typically impact our clients. But the one takeaway, and just a reminder for everyone, is that the Marketable Record Title Act is fairly complicated. And if you are a board member or a manager of a homeowners association or a condominium association that has a master set of covenants and restrictions or recreational facilities, you need to be aware of the MRTA statute and discuss it with your attorney, because it could have the impact of extinguishing your covenants and restrictions if certain action is not taken by your association. So the operative date to keep in mind is 30 years after the date that your covenants and restrictions were recorded, and certain actions have to be taken before that 30 days. Like Ken said, this is not really applicable to condominium associations, but if you are an HOA or like I said, a master condo or recreational facilities, it's something to keep in mind and talk to your attorney about.
Jelini, before you go to the next provision or the next bill that passed this year, we've already received a lot of questions about the engineered life safety system deadline, because people are seeing that deadline coming. And Steve, I think you can confirm for us that there was no consideration this year of modifying that deadline, and there's not likely to be further consideration to modify that deadline.
Right, that's my understanding as well.
So for those of you who are thinking there's going to be some last minute change in that deadline, if you're not making plans to be prepared to meet the deadline and install an engineered life safety system, you need to start making plans. You need to do it now. Back to you, Jelini. 438 passed regarding flags. And I want you not just to speak about the flag that was added to those that are permitted, but speak generally to the concept of flags in communities, because it's going to be a hot topic along with political signs as we go into an election year this year and as we go into an election year in 2024.
Yeah, so what this bill does, it's limited and it changes the statutes in 718 and 720, which is the condo and HOA statute, to add that owners are also allowed to fly the Space Force flag, because as some of you may know, those statutes specifically state that owners are allowed to fly the US flag, and then during certain holidays, like Armed Forces Services Day, Memorial Day, Flag Day, Independence Day, etc., they are also allowed to they're also allowed to fly these other flags of the military or armed services. So like the US Army, Navy, Air Force, Marine Corps, and Coast Guard flags. So what this bill does is it adds the Space Force flag because that is now a new armed services branch. So that's all that the bill does. What Ken was
With regard to the United States flag,
Mhm.
there's language that says it has to be flown in a respectful manner. Is there any source of authority to explain exactly what that means? I mean, I had one association in the last couple of months where somebody draped it over like a beach chair and over the railing. Is there guidance in state or federal law on what it means to fly the flag in a respectful manner?
There is, and it's a federal statute and it provides some guidance, but there's really no enforcement or penalties related to it. It's but it has things like should be flown only during the day and flown, taken down at night, and you're not allowed to have, not supposed to fly ripped flags, that sort of thing. But as far as whether, but you see in communities all over the state of Florida, people leave their US flags out all the time. Another thing that is in that federal statute is talks about the flag has to be illuminated. So, none of that really is has ever been enforced as far as I know. And, I don't think there's any penalties for that. So what we tell our clients is to, if you want to have the ability to regulate the types of flags that are flown in your community, because like you said, this could be a hot button issue later. If there is no restriction on flags, then what other types of flags can be flown other than the ones that are mentioned in the statute? So if you were to pass a rule or an amendment that says only the flags that are listed in 718 and 720 are the types that can be flown, then you can avoid hopefully some of these disputes as to whether or not other types of flags that could, provide some controversy in your community can be flown or not.
And I think it's appropriate to mention that the United States flag means the real flag, not some adulterated version, whether it has, the picture of a political candidate or other modifications to suit some political cause. The American flag is what we all were taught in high school and elementary school is the American flag, the one we used to all say the Pledge of Allegiance to. It is not some adulterated version.
Right. I agree with that.
Steve, let's talk about tree trimming and tree removal. It has been my understanding frankly, for decades, that the common law in Florida is that if your neighbor's tree limbs or tree roots extend into your yard, trimming them back is your right, but your responsibility, not your neighbor's responsibility.
And that still holds up. What the legislature did, it's the House bill is 518. They were looking at the intersection between home rule powers, which means that the counties and municipalities can make their own rules if the state hasn't occupied that particular subject matter. And if we just go back to 2019, the legislature amended what is Florida statutes 163.045, and it allowed an owner of property to have a tree removed if they could get an arborist to certify that it was a danger. And I can remember that statute became effective July 1, and on the news that night, there was a story about a mobile home park that removed several trees based on an arborist letter on July 1, and they got it done. That legislation led to some lawsuits and some unhappy people. So they've totally pushed it back. And we're going back to the common law that you're referring to and things the way they were, with the one exception, and this will only apply to private single family homes. So no more condominium associations being able to do this, or the mobile home park in my example. And it would require you have an arborist indicate that it is an unacceptable risk. There's a group called the Society of Arboriculture and the American National Standard Institute, and they came up with all these definitions of what is a risk, and you'd have to have the tree certified by an arborist to be an unacceptable risk, be a single family detached home, actively used for single family purposes, then you can do it. Otherwise, you're back to home rule. So whatever your city or county provides, you're going to have to do that. And I think along the way, Ken, this was a fundraiser for the cities and counties because they're going to get their permit fees for all this, as well as being able to require mitigation and everything else. But that's what they've done to our trees.
So in a homeowners association, for example, where you have a homeowner's owned lot adjacent to the association's owned property, perhaps where a green space or a park area, or maybe trees planted around the pool or the pool deck. How will this law apply in that circumstance where either an owner's trees on his property might have roots that are perhaps damaging the pool deck, or the association has trees on its side of the property line that is damaging the owner's structure?
Well, if the owner's home qualifies as being that single family detached home, they can do what they need to do if an arborist certifies that it is an unacceptable risk. If it's the association's tree from the common area coming onto the owner's property, not so much. You're back to that common law thing that you were referring to, chopping the root down the lot line, if that's what the owner wants to do. And I don't think this is a satisfactory result. I know there's some opposition to this, people urging the governor to veto it for a variety of reasons, but I understand the counties are pushing for it because they do want that local control back.
Well, I appreciate the clarification, because one of the questions we get regularly is an owner complaining about landscaping on association property that is either damaging his property or obscuring his view. And I don't want anybody to leave this webinar thinking that the owners now have the right to. I actually had one owner trim a window in the hedge so that he could have a view of the ocean. This law is not intended to create a bunch of George Washingtons who are going to go out and chop down other people's trees or the association trees.
Correct.
Steve, the other bill I wanted you to discuss was 898 regarding tenant safety, because it might have some points that are helpful to associations that engage in meaningful screening of tenants and buyers.
Yeah, thanks, Ken. Yeah, 898 is what they call Maya's law. It's regarding tenant safety. This relates to a young lady who was, I believe, in Orlando, allegedly killed by a maintenance worker employed by the community that she lived in. And there's a rental community who apparently used the master key fob to gain entry to her unit. And this is to require landlords of transient and non-transient apartments to require employees to undergo background checks. And so it defines what that is. And a background check must be done by a consumer reporting agency in accordance with the Fair Credit Reporting Act. As a condition of employment, it must include criminal records, sexual predator and sexual offender reports from all states, including the District of Columbia. Then it goes on and tells the employer that they can disqualify a person from employment based upon that background check if they have been convicted of, found guilty of, entered a guilty plea, or no contest, regardless of adjudication, to any of the following: a criminal offense involving disregard for safety of others, if committed in Florida, would be a felony or first-degree misdemeanor. If committed in another state, would be a felony or first-degree misdemeanor if committed in Florida, or criminal offense in any jurisdiction which involves violence. And this is kind of interesting. Violence, including but not limited to murder, obvious, sexual battery, obvious, robbery, carjacking, home invasion, robbery, then it says, and stalking.
That's
So,
an addition, isn't it?
yeah, because we know we can have cyber stalking, and people generally are a little more surreptitious in their stalking, but they call that a violent offense. Now you look at me and say, well, Steve, why would we be looking at this? Because we don't employ people. What I'm recommending for our clients would be that we look to this statute, and it's going to be in 83.515 of the Florida statutes for screening of tenants, perhaps screening of occupants in condos and homeowner associations, as well as employees. But I think this will have a greater application for us than we might otherwise anticipate, because it's a hard task to describe what kind of applicant or application should we reject. And this will give us guidance in it'll be hard to argue with standards that are part of another Florida statute. So I look forward to using this in my drafting of amendments for clients.
Well, it's important for everyone listening to bear in mind that there's nothing in Florida statutes that grants your association the right to approve or disapprove buyers, renters, occupants. That right has to be provided for in your governing documents. Without that, this screening provision is irrelevant. It's informative, educational to people who have the right to screen for how to engage in meaningful screening. So not only does the statute not grant you the right to screen, the statute doesn't necessarily grant you the right to say no. That's also a document issue. So for those of you listening who do screening, be mindful that the statute is not creating new rights for you. As Steve is pointing out, it's giving you some useful guidance as to how to properly structure a screening application and structure a screening process. Fair statement, Steve?
It is. My only other caveat is this is limited to the 50 states plus the District of Columbia. I think we have a fair number of people coming to our communities who come from other countries. Getting a background check may be a challenge for many of those persons, so be careful.
Thank you. Jolene, let's come back to you and talk about protests.
Yeah, so this bill is HB 1571, and not super, applicable to condominiums and HOAs, but it could. It basically says that it is unlawful for a person to picket or protest before or about the dwelling of a person with the intent to harass or disturb that person in his or her dwelling. So, that could potentially happen in your community if there is somebody controversial living in your community, and this law would prohibit somebody protesting or picketing in front of a home. And it is a violation. The violation of the statute would be a misdemeanor of the second degree. And so it's just something to keep in mind that is now prohibited.
All the board members listening are about to ask the question, which is, does this mean that if owners start to circulate information that says that the board doesn't know what they're doing, they're all criminals, they need to be thrown out, that this statute somehow grants them some recourse?
No, I think it has to do only with picketing or protesting in front of a dwelling or around the dwelling of the person.
And if you've got people in your community who are willing to go that far to actually load up on signs and picket in front of the board members' units or the board members' homes, perhaps you have some ammunition now.
Right.
Okay, Steve, I want to come back to you for the last two bills that passed before we talk about the two bills that didn't pass but might still be considered in next month's special session. The first one is 967 regarding an exemption for golf course irrigation and fertilization, and the other one is House Bill 741 regarding net metering for solar power.
It would go to the golf course best management. There's a certification for persons who've undergone the training for best management practices. And what they're looking at is curbing excessive and unnecessary fertilization to prevent water pollution. If you have such a person, you have a golf course, you can become exempt from the training and local ordinances dealing with water and fertilization use. There's an exception for when there's a state of emergency declared, and there's also an exception if your property's in a basin management plan. The other one that you're referring to, Ken, talks about returning power to the grid. It's interesting because we have a local builder who sells homes on that basis, that you can have a zero energy home and make money from putting power to the grid. The power companies have said, no, we don't really want that much going on. So this would curb it and basically phase it out over a number of years. So they're trying to work on getting people grandfathered in before it comes into effect. This bill also is drawing a lot of resistance and opposition, not only from the home builders, but from people who have planned on returning power to the grid. So stand by on this one.
And with that, I want us to turn to the bills that did not pass but are going to be reconsidered in the special session. And I think most people recognize that these bills are either going to pass in the special session or they're coming next year. So I think everybody needs to be aware of what's in these bills, what's likely to pass, and the significant, maybe the most significant ramifications from legislation in many, many years in Florida for condominiums and cooperatives and any buildings that are more than 3 stories in height. So let's break it down. Let's first talk about mandating inspection reports. And I'm referring, of course, to the proposed new 718-132. And Steve, I want to start again with you, and then Jelini, I'm going to turn to you to talk about the consequences for people that don't follow these requirements when they become law. Steve, the inspections basically fall into 2 categories. The first is the certification inspection, and then depending upon what that inspection finds, which is more of a visual inspection, but based upon what that inspection finds and who's required to perform that inspection, specifically an engineer or an architect licensed in the state, it triggers what's called a phase 2 inspection. Can you talk about what that process is likely going to require, how frequently the reports are going to be required, and what is required to be done with those reports in terms of disclosure to owners, disclosure to tenants, disclosure to prospective buyers, and most importantly, disclosure to the local building department?
Yeah, it's kind of interesting. There are 2 different bills in play. Again, neither of them passed. So one is Senate Bill 1702, the other is House Bill 7069. Those of you who are students of the legislature, anything beginning with a 7 is from leadership, and it should have passed. It's like, and we mean it. But at the end of the day, when the session ended, they couldn't reconcile these. This is one area where they are pretty similar, but there are differences. The certification process is going to apply to buildings 3 stories or higher. Generally, the first inspection is going to occur 30 years after initial occupancy. That's the 7069 provision. Then 25 years after initial occupancy if they're within 3 miles of the coast. And obviously, we have a lot of housing in Florida up and down the coastline. So we have to pay attention to that.
Steve, you said 25 years after inspection. I think you meant 25 years after construction.
After initial occupancy, I'm sorry. Thank you. In the 3 miles within the coast. The 1702, also 3 stories or higher, 30 years, and they're saying every 10 years. But if you're within 3 miles of the coast, it's going to be every 7 years. And the 1702 had a lot more detail in it about the first inspections and the final inspections and so forth.
Before you go into that detail, Steve, again, pardon the interruption, but for
Sure.
buildings that are already there that are over 25 years of age, that are within 3 miles of the coast, and for buildings that are not, that are already over 30 years of age, what are likely to be the deadlines for these associations to get these reports done when this becomes a law?
Yeah, absolutely. The 1702 was more specific about it and said by December 31st of 24, if the certificate of occupancy was before July 1 of 92. So that's that 30-year and older property. They're saying you have to have that one done by December 31st of 24. If that comes up in the second special session, right now, the second special session that you referenced is specific to insurance, kind of a factor for all of our clients paying insurance, obviously. But there's a lot of pressure from legislators to add these bills to get this done as well. And I think that's obviously going to happen. The reports, as you're indicating, are going to be provided to every unit owner. They're supposed to be posted on the website. In one of the bills, they have to go to the local building official and also to the state. What they're looking here for is transparency. Prospective buyers have to be provided with a copy of the most recent report. Developers have to provide them. They're making sure that no board or no manager can sit on it. And while I'm talking about managers, there's an obligation of the CAMs to make sure that these bills get filed where they're supposed to be filed. So if you have to provide it to the state or to the local building official, it is the CAM's responsibility to see that it is done. And if they fail to do so, they are subject to penalties for not doing that. It's also a fiduciary duty of the board to make sure that the inspections and the repairs are done. So they
I
are
want to
increasing.
pause you there for a second. I wanted to allow Jelini to discuss some of these important footnotes, if you will, in the legislation. And they're not really footnotes because you might view them as boilerplate, but they are of substantial importance because for many, many years, the Condo Act has identified 3 or 4 criteria for individual liability for board members. They were, criminal conduct, self-dealing, gross negligence, or recklessness that shows a disregard for the safety of the person and property of the owners. These bills would add a 5th criteria for potential personal liability for board members, correct?
Yeah, so, and as I was reading these bills, as you mentioned, there were 2 separate bills. There was a Senate bill and there was a House bill, and they had some differences. And it seemed to me that it's the House bill that has some more of these penalties included in the language of the bill. So that's one of the things that's going to have to be, I think, reconciled once these issues are taken up again, either in a special session or next year. But in the House bill, like you said, there was language that says that the failure to complete a recertification or a phase 2 inspection pursuant to the requirements of the statute, such failure is a breach of an officer and director's fiduciary relationship to the unit owners.
Which is code for personal liability.
Right.
If I recall correctly, the bill also said that failure to timely perform the report could result in a mandatory evacuation of the building.
Right. So it provides that the association has to schedule the repairs, within a certain period of time as required by the county. They're supposed to submit this inspection report to the local building official. And then that period of time that they're supposed to make the repairs cannot exceed 365 days after the local building official receives the phase 2 report. And if it's not done within that period of time, the local building official must determine that the building is unsafe and must be evacuated. Well, must be unsafe, which means that the building would then have to be evacuated. The House bill also allows the local building official to impose penalties. It doesn't say specifically what those penalties are. So I am interpreting this to mean that each local building official will get to decide what penalties are going to be imposed in their particular jurisdiction.
Which are typically financial, like a daily fine of $500 or something.
Right. So yeah.
But I want to steer you to a point though. I don't want the people listening to think that they can count on the local building department to make sure that they meaning the board, does its job here. The local building department has the benefit of the Trianon case, which gives them immunity from liability. But stating that these are a breach of fiduciary duty, as I said, it's code for saying that if you don't get these reports and you don't act on these reports, the action or inaction of the local building department is not going to serve as any sort of a shield to the association or its individual board members or managers.
Right. Ultimately, it's going to be the association and the board members that folks are going to look to in the event that there is, some kind of tragedy. So, again, making sure that you have adequate insurance for your officers and directors is going to be important.
Well, and Steve said a few minutes ago that these reports were intended to provide a level of transparency. And I agree with that, but I think the portion that you've just addressed shows that transparency is only part of it. These bills are intended to mandate and enforce some action in response to the requirement to get the report and in response to the findings in the report. So these reports are not window dressing. These reports are going to trigger action. And I think everybody is sensible enough to know that engineering reports are probably going to become less progressive and more conservative in terms of their findings.
Yeah, Ken, a couple things there. One, now's the time to hire that engineer and get
Thank
going.
you for pointing that out. I've been saying that to clients because once this becomes the law, engineers are going to be tough to find and their fees are going to be much higher.
No doubt. And if you can get a report done now, they may have to do a supplement. If the standards change when the legislation eventually is enacted, it's a lot easier to get that supplement done than to get the entire report done. But to Joleni's point about the insurance, we're
Excuse me,
seeing,
before you go to the insurance,
yeah,
I want to reiterate, for those of you who think to hire an engineer now, which I concur with Steve, it's a good idea, make sure the engineer is familiar with the requirements of what this bill will be when it becomes the law, so that the work that the engineer does in the inspection complies with the law that is coming, not just with what the engineer would do today. Go ahead. I'm sorry, Steve.
yeah, on the insurance point, we're starting to see the insurance companies asking for these reports. So it's somewhat circular that the insurance company is going to say, you have to have that in place before we're going to insure you. So when we get to that breach of fiduciary duty issue, it's not as much a concern if you have the correct report in place already. So the insurance companies are watching this as well, and you may be declined insurance if you don't have it already or in process.
One of our listeners has sent in a question saying, aren't you worried about board members running for the exit? And the answer is, of course. Most elections, when you send out the request for people to submit their notices of intent to run for the board, it does not resemble the Oklahoma land rush. Usually the people left are the ones who don't take a step backwards. Serving on the board is not necessarily a coveted position. And sometimes the people who want it most are the people you least want on the board. I would respond to the question, if you're listening, Scott, that I think the legislature and your council and your manager will give you ample guidance for how to comply with the law. You will have findings, you will have legal advice from your lawyer, you will have engineering advice from your engineer. It is then incumbent upon the board to act on that advice. And as long as you do so, you are fulfilling your duties. Before we leave inspection reports, Jolene, Steve, any other comment on the inspections, particularly the phase 2 inspections, which are destructive or non-destructive, but the phase 2 inspection is a much more intensive inspection of the property.
Yeah, and it's triggered if the phase 1 identifies what they call structural distress. So the visual cracking would probably be the example, but it's going to be up to the engineer to call for it. And it does trigger the need to make those repairs. And it's a far more onerous situation. And I want to tag on to your comment to the person who asked the question. You know, this is for safety. It's really, yes, it's going to be expensive. There's no doubt it's going to be expensive, but I think it will give people greater confidence in their homes and their buildings and in their boards. So it's really not that bad. It's just going to be expensive to implement, but once we've got it in place, it should be fine.
I want to piggyback on your point, Steve. This is about safety, but I want to reiterate what it's not about. It's not about cost.
Right.
Any community that is making maintenance decisions based upon cost rather than need is making a significant mistake.
Yeah.
Period. You cannot let the concerns of the owners who don't want to spend money dictate your actions as a board. Better they should vote you off the board than you should allow decisions to be made by people who don't want to spend the money that is required to maintain the building. Remember this to the board members listening. You owe a fiduciary duty. The individual members do not. You're held to a different standard once you choose to join the board. And with that, I want to go to an issue, Steve and Jolene, that is much more of a transparency and disclosure issue, which is the changes that are coming for reserves. For decades now, the law has required the budget for a condo or a co-op to attach what is called a reserve schedule. And that reserve schedule is required to show every reserve component, which is the roof, the paving, the painting, and any other component for which deferred maintenance or replacement costs will exceed $10,000. And for each of those items, show the total useful life, the total remaining useful life, the estimated deferred maintenance or replacement cost. And if you do your reserves based upon a straight line or what's called a component basis, the estimated balance in the reserve for that particular component at the end of the current fiscal year. For many, many years, there are associations who have either not attached a reserve schedule or who have attached one with information that was pulled out of I don't know where. Maybe it was based upon the estimates of a treasurer who has been deceased for 20 years. Maybe the numbers were simply pulled out of the air from a Google search, but I cannot emphasize strongly enough the value, regardless of this new legislation, of having a reserve study done by a qualified reserve analyst so that you as board members, and frankly, so that your owners can know what expenses are coming, when they're coming, and how much they're going to be. Nobody can run a business without that kind of information. None of you listening ran your business without that kind of information. And your associations are multi-million-dollar real estate operations with 6, 7, sometimes even 8-figure budgets. You cannot run that business without fiscal planning, including information about when the big capital expenditures are coming and how much they're going to be. Now, the option to waive or reduce reserve funding is very likely going to change. And it's going to change in a way that will deprive the owners of the right to waive or reduce the reserves for certain structural components, which are identified in 718-301. I want to talk about this because I've already articulated the value from my perspective as an association lawyer of the board getting a reserve study. But Jelini, can you discuss some of the included components that are going to be exempt from the owner's right to waive or reduce, and when how often these reserve studies are going to have to be done, and when the first one will be due?
Yeah, so again, this is one of those issues that's a little bit different in the two bills that the legislature was considering during this session. So it's going to have to be resolved. But in the House bill, there was a requirement to do what was called a structural integrity reserve study every 10 years. And that would apply to any building or any condominium with buildings of 3 stories or more. And it would require that reserve study be done based on a visual inspection by a licensed engineer or architect. And the study would have to identify the common elements that were inspected, the remaining useful life, and estimated replacement costs for those items that were visually inspected, and provide a recommended annual reserve amount. The Senate bill was different, and it required a reserve study to be done every 3 years. So there's a difference in the date that it would have to be done by, or how often it would have to be done by. And then in the House bill, it would require that the first structural integrity reserve study to be completed by July 1 of 2024. Now, I don't know if the bill passes during a special session or next year, that date might change. But as Ken said, even without this law in effect, this is something that associations should be doing anyway, because, how else are you going to properly fund your reserves if you don't have the correct data and information? So the items that the reserve study has to include would be things like the roof, load-bearing walls, and other primary structural members, the floor.
The primary structural members are defined in 627-706 as, I believe, the support columns that support the building. I'm not rendering an opinion on that. That's something for your engineer to look at. But primary structural members is actually a defined term in the statute.
Right. It refers back to that 627. Fireproofing, plumbing, electrical, waterproofing and exterior painting, windows, and any other item that has a deferred maintenance expense or replacement cost that exceeds $10,000. And the failure to replace would negatively affect the items listed above. or which were the ones that I previously mentioned. And again, that has to be determined by the engineer or the architect. He would determine what additional components would need to be included. So, and I think there's some language in the statute. I don't know if you want me or Steve to talk about it, about the waiver and how that is going to change the
I'm
ability.
going to let Steve be the bearer of the bad news about the waiver and reduction. But I just to add some color to your comments, people are used to funding reserves, for example, for the lobby interior, for the office furnishings, the pool deck, the painting of the exterior, the paving of the parking lot. Those things are not necessarily included in the list of items for which reserves cannot be reduced or waived. But I would proceed very carefully on anything that impacts structural support, even if it's connected to a structural member or some other structural component of the building. This is something that is going to require the reserve analysts to have greater involvement from engineers and architects in developing these numbers and in advising you as to what qualifies as a component for which reserves can or cannot be waived or reduced. Because remember, the last component Jelini mentioned was any other item that has a deferred maintenance cost or replacement cost in excess of 10,000, the deterioration of which could negatively affect any of the structural items mentioned. So this is going to become a much more complicated process developing a reserve study, and you're going to have to be very cautious and probably consult your engineer with regard to what items can be voted on for waiver or reduction, even if they're not expressly listed. And with that, Steve, unless Jelini, you had more, I want to turn it over to Steve to talk about the impetus for this change in allowing a waiver or reduction and whether or not one of the bills allowed some alternative funding methods.
Yeah, it's interesting. Again, Ken, it's one of the inconsistencies between the bills, and urban legend has it this was the one that got the legislature most hung up on the last day.
No, it is an election year.
Yes. And there's, yeah, the influence of it being an election year cannot be overstated. The House bill said effective January 1 of 2024 that associations, condominium associations, and this does also apply to co-ops, and one of the questioners asked about that. You know, if you're 3 stories or higher, everything that you've been hearing will apply to your co-op as well, but may not waive full funding of reserves, may not vote for using reserve funds for other purposes, kind of shorthand, because we're used to majority at a meeting can do that, or something else might be provided in your documents. But House bill had it as a total ban. The Senate bill said that it would be a majority vote of all owners. Again, increasing the standard slightly. If you're used to the majority at a meeting, it would be a majority of all owners to waive full funding of reserves or using reserve funds for another purpose. So I do anticipate there will be a change in that statute when it finally comes out. Which one it will be, I don't know.
It is important. I guess one of the takeaways, folks that are listening, is we already heard from one board member who's already filling out her resignation letter, I believe. But your owners, and particularly for those of you that have owners who bought at a time, or whose parents or grandparents bought at a time when property values were substantially less, and who are struggling to cover the costs associated with owning a unit in your building now, especially if you're an oceanfront building, the cost of living in and owning a unit in a condominium is going to go up, because there are going to be changes in the legislation that are going to require reserve funding. Steve, one more time, the alternate funding methods, which I did not find to be particularly clear. Is there anything to be gleaned from that, or should people just assume that some funding of these reserves for these components that Jelini listed? And for those of you who want to read this is you can read Bill 7069 at line 876, which is where you start to see the list of the items for which a structural reserve study are going to have to provide explanation, funding requirements, and which are not going to be subject to waiver or reduction. Steve, do you have any idea what sort of alternate funding methods are going to be proposed?
No, and Jelini and I were just talking about that, excuse me, before we started. It's in 1702, and it refers to alternative funding methods. And let's face it, that means it's going to have to come from the owners somehow, but it could be a little bit slower by way of borrowing from outside sources, getting that line of credit. Those of you who might have seen in the news, 2 of our local congresspersons filed a bill in Congress to open up federal funding for condominium unit owners. It was Congressman Chris and Wasserman Schultz, and it's House Bill 7532 in Congress. It got filed on April 18th and would allow for loans for condominium unit owners for making these repairs. But that program that they're looking at, I've got to tell folks, it's limited to low income families, and your building would have to be FHA qualified. So if you saw that and say, well, that's what they're referring to in 1702, it might help some people, certainly, but it may not be helpful for everyone. So yeah, beyond that, Ken, I don't see a good alternative way of funding it other than the loan or special assessment.
The one of the questions.
Can I add something, Ken?
Go ahead, please.
Yeah, on the Senate bill, as I was reviewing this, I noticed that they included a provision that specifically said that the board would have the authority to take out a loan or borrow money or pass a special assessment for these types of repairs, even if the governing documents required a vote of the owners. So, I mean, that would be helpful if that would end up passing. I know some owners don't like to hear the board is just going to adopt a special assessment and would have, unfettered authority to do so, but it does give them some tools to get the money that they need. And even borrowing money, sometimes there are governing document provisions that require a vote of the owners for that, and that would be helpful in that you could spread the cost over a period of time, and that would be helpful for owners as well.
And it's an important point, because it's something that as lawyers we've wrestled with, because there are a lot of developer documents or even documents that have been amended by the owners that severely curtail the board's authority to borrow and to levy special assessments, or levy special assessments above a certain amount or borrow above a certain amount. And those provisions have often become roadblocks to the board doing what it's required to do to maintain the condominium property. And the legislature has finally seen fit to begin to address that, because it is a problem. Because if you serve on a board and you're required to perform maintenance, guess what? You've got to be able to pay for it. And if the maintenance isn't adequately covered by your existing reserves or isn't adequately covered by your operating budget, you either are going to get the money by getting a line of credit and levying an assessment as collateral for that loan, or levying an assessment to pay for it directly. One of the questioners asked about how the board members are going to learn about all this. If you are a client of this firm, you will learn because you will get a call alert. You will get a call alert from Jelini or Donna Berger, who's the chair of our call practice, which is the Community Association Leadership Lobby, which issues alerts throughout the legislative session and frankly throughout the year. If you are not a client of this firm, you need to look to your manager and your attorneys to keep you apprised of what your obligations are here. Jelini, speaking of the managers, I want you to reiterate a point, because Steve alluded to it earlier, which is that for the managers listening, these new laws will impose obligations upon you that can result in disciplinary action if you don't comply.
Yeah, this is from the House bill. The Senate bill did not have this. So again, it's kind of indicates that the House bill was trying to provide additional penalties and give these new laws some teeth. And so it included some changes to Chapter 468, which is the chapter or the statute that regulates community association managers and management firms. And it's required, there's a specific provision that requires the managers to comply with 718-132, which is the provision that requires the inspection reports to be done, the recertifications and the phase 2 report if necessary. And it was also amended to state that the managers can be disciplined for failing to provide the written certification report to the local building official. And it also explains that the disciplinary proceedings are brought by DBPR, which is the agency that regulates community association managers. And it includes things like penalties and monetary penalties, revocation or suspension of a license, and reprimands and probation. So all of those types of disciplinary proceedings are available to DBPR for managers that do not comply with these new requirements of the statute.
Steve, I want to come back to you on the last topic, and you alluded to transparency, and I'm going to refer to it here as disclosure. Unfortunately, there are boards who think that it's not a good idea to disclose a reserve study to the owners. They're afraid, they don't want the owners to see how much it's going to cost. They think somehow that disclosing the reserve study means that you have to fund more. What it means is you have to budget more. But up until now, it hasn't precluded the owners from voting to waive or reduce reserve funding. Similarly, I've seen some boards try to exercise some sort of a pocket veto for engineering reports and not disclose them either to the city or to the owners for fear that it will panic some of the owners or affect property values. I'd like you to discuss, if you would, Steve, as our closing comment, the importance for board members to treat this information as an official record that is subject to inspection, not just in the traditional sense, but even by additional parties and additional disclosures.
Yeah, I think you've just said it quite well, Ken, that's what this is all about, that the board members actually probably breach their fiduciary duty by keeping this stuff, by trying to keep it away from the owners. One of the bills, and it's in the House bill, allows renters the right to inspect it. I think we're all aware that the right of renters to inspect the official records has kind of crept up slowly over the last few years, but this would add all of the certification reports, all of the reserve studies as being available to renters and to prospective purchasers. So if they can see it, certainly all the owners must be shown copies of these documents. Ken, I think we need to just do a quick comparison of a couple things that are in the bills that are kind of sleepers. For example, in the Senate bill, the post-election certification by new board members must be in the form of an affidavit, and they have to certify that they have read, understand, and will enforce the documents and take the class. So those of you who are board members, do stay on the board, don't get off because your certification is going to be good, but it's something else to look for. And also the termination, if that phase 2 report comes up and it says that the cost of repair is greater than 65% of the fair market value, the majority of the owners have a right to terminate the condominium. And I'm not advocating terminating condominiums, but if you find yourself in that position, there is a way out. So with that, back to you.
I'm gonna ask for final thoughts, and I'm gonna go first. To the board members listening and to the managers listening, do not substitute your judgment for that of the engineer. Do not ask your lawyer to substitute his or her judgment for that of the engineer. And I'm going to give you a specific example. Fannie Mae has modified its questionnaire for Fannie Mae backed loans. And part of that questionnaire requires you to answer questions about the condition of the building. With all due respect to the board members and the managers listening, you're not qualified to render an opinion to a lender upon which the lender is going to base its decision to make a loan to an owner in your building on the condition of the building. That's not your role. That's not your responsibility. I'm not suggesting that you refuse to comply with prospective lenders, because I think most of you want to facilitate your owners and prospective purchasers getting financing. But I do not believe you need to extend that courtesy so far as to extend yourself to rendering opinions you're not qualified to give. What I have advised my clients is that when those questionnaires ask for you to render opinions regarding the condition of the building, you respond by saying we're not qualified to render that opinion, and your borrower, to the extent the borrower is an owner, or if your borrower is a buyer, the prospective seller, has the right to request copies of any engineering reports or other inspection reports we have in our files. And we are glad to make them available, and they can be transmitted to you, but please do not attempt to render opinions either to the lenders or frankly, even to your own owners as to the condition of the building. That's what you hire an engineer to do. Jelini, final thoughts?
I would just say, don't wait until this bill becomes law to start planning for an engineer or an architect or even a reserve study, because many associations haven't done a reserve studies in many years and don't do them regularly. So you need to do that as part of your standard operating procedure, and make sure that it's updated regularly, because even if it's not law now, it will be in the future.
Thank you, Jelini. Steve, any final thoughts?
Just tagging on to what you were saying, Ken, the whole concept here is really positive because it is going to give you that safety and the confidence. It's going to have the engineer or the architect helping the board make the right decisions. And in response to one of the questions, the engineer or architect has to be qualified in the area in which he or she is giving the opinions. It should make life in condominiums better for all. It'll certainly be safer. Yes, it will be more expensive to begin with, but overall, I think this is a drastic improvement, and we look forward to seeing it.
Obviously, stay tuned to what is going on in the special session, or be prepared for what's coming next year, because it is coming. And with that, I will say thank you again for attending. I hope you found the webinar to be educational and informative, and we look forward to seeing you soon. All the best.